Good evening, ladies and gentlemen. We absolutely believe in the power of innovative entrepreneurship on every level. That's why we are exploring ways to improve our education wing by making it as effective as possible. I, Priyanka, on behalf of Federation of Indian Industry and Professionals, welcome you all to the leading Industry Insights wing to educate and make aware mankind in the country and globe. Today, Federation of Indian Industry and Professionals is organizing, through its Industry Insights wing, the live webinar on branding strategy and legal challenges by our guest speaker, Dr. Mohini Suryawanshi. Here are some house rules for you. Keep your phone in silent mode. Rename yourself with mobile number. Put your queries in the chat box. Keep your notepad and pen ready. Note down all the relevant points for discussion. Also, for your information, a recorded version of webinar will be available on YouTube and Facebook. Thank you. Now, it is time to learn the fundamentals of the Federation of Indian Industry and Professionals. Unite together, succeed together. The Federation of Indian Industry and Professionals is a unique, multi-stakeholder organization of visionary industrialists, businessmen, and professionals who share a commitment in shaping the future of industry and society at large. The Federation of Indian Industry and Professionals is a not-for-profit organization. FIIP was established on the 1st of October 2020 with the objective of boosting a small and medium business movement across the country and becoming the voice of India's various business sectors. It serves its members and the whole society through the private and public corporate sectors within the country. FIIP is a lifeline for new startups, small and medium business leaders. It is a crucial platform for networking and collaboration for each stakeholder who is working for the nation-building cause and to build Atmanirbhar Bharat. FIIP is actively engaged in the welfare of business community and general society. It encourages debate and organizes engagement programs with policymakers, Indian private and public corporate sectors, multinational companies, regional chambers of commerce, industrial associations and professional associations in each state of the country. FIIP has created a cluster network of 40,000 plus GST practitioners and made available a platform for networking and consensus building within and across sectors, and is the best platform for Indian industry, policymakers and the international business community. Vision: to facilitate and boost entrepreneurship and entrepreneurial development in the country, to support socio-eco development leaders throughout the nation, to encourage women power in various fields, to make Atmanirbhar Nari. Mission: creating a world-class talent body of 5 lakh influential and powerful industrialists, entrepreneurs, businessmen, women, and professionals through FIIP platform within 10 years. DNA: sustainable growth, empowerment and creation. Purpose: helping business people, supporting economic development. Creating industrial insights, inculcating industrial development. Facilitating forums for professionals, solving problems with the right solutions. Enhancing skills among business owners, and creating a common platform for building interpersonal relationships. Support for micro, small, and medium enterprises businesses, formulating applied strategies to meet challenges of various industries. Making society aware of social, health and environmental issues. FIIP has various business platforms such as Network, Industrial Insights, Karta, Spot, Digital, Womenpreneur and NavUrja. These platforms facilitate to make our country Atmanirbhar Bharat in the field of socio-eco environment, education, social and life. Now, it's time to present you Industrial Insights topic for the day. We all know that business is an organization or enterprising entity engaged in commercial, industrial or professional activities. And of course, business is to earn profit. Business comprises very many functions like marketing, sales, service, finance, purchase, R&D, engineering, logistics, human resource, personnel, facility, quality and many others. Further, these functions will have various systems and processes. We need adequate knowledge and various skills to practice and execute these systems and processes, and handle these functions to run the business or an enterprise and achieve desired results. This is where industry insights play an important role in providing inputs on various topics for all kind of business categories and professionals. Industry Insights will have series of programs organized every fortnight, and it will cover topics in different categories like financial management and accounting, marketing, sales and service, managerial skills and people management, project management and planning, quality systems and quality management, business establishing process, government policies, support system, and legal aspects of business, and many more. These main categories will have very many subtopics to comprise all information and contents. For example, financial management and accounting will have financial planning, management accounting, auditing, taxation, etc. etc. Marketing, sales and service category will have brand management, digital marketing, handling objections, customer retention, etc. Under managerial skills and people management, we will have leadership skills, team building and motivation, delegating skills, analytical skill, and many more topics. Project management and planning category will have project planning and budgeting, resource management, risk management, strategic alignment, etc. etc. Under quality systems and management, there will be topics like 4 main elements of quality, 7 principles of QMS, total quality management, ISO, etc. etc. Government policies, support system, and legal aspects of business will cover topics like government schemes and policies, role of banking in economy, role and support of MSME, etc. The laws to maintain the decorum as per state and central government. With this brief about the industry insights, now I request our programs coordinator to take over for introducing today's topic and the speaker. Thank you.
Thank you, Priyanka. Good evening, everyone. So branding is important because not only it makes a memorable impression on a consumer, but it also allows your customers and clients to know what to expect from your company. Branding creates a loyal customers. Branding is a way of distinguishing yourself from the competitors, right? You're all aware about this. So strategically creating and building your brand is critical, and understanding legal aspects is crucial. So I am C.V. Katrabad, Director FIIP, and happy to welcome you all on this important session of Industry Insights today. So today we have a topic titled Branding Strategy and Legal Challenges. Okay, as you are seeing on the screen. So for this, we have a special guest speaker, Dr. Mohini Suryawanshi, who will talk on this important topic today. So friends, let us welcome Dr. Mohini Suryawanshi, a prominent IPR expert. So before I hand over to the forte to Dr. Mohini, I would like to brief about her. So Dr. Mohini Suryawanshi is a PhD in biotechnology, and she has also done a degree in law. She is a registered IPR attorney, an agent and attorney and trademark attorney. She has also been awarded Women Scientist and Fellowship by Department of Science and Technology. She has a recognized Government of India a patent and a trademark facilitator for guiding startups. She has established her own company called Intellex Empire in 2015. Prior to that, she was associated with well-reputed firms. For example, Krishna and Saurashtra Associates, Bangalore. It is a law firm. Okay, and another company called Avestagen Limited, Bangalore, an invention-oriented company, etc., etc. Primarily, she is practicing IPR law, but she also works in different technology domains. Okay, to product inventions and plural technologies. She is well versed in all kind of activities of IPR, like analyzing, filing, prosecution, valuation, litigation, commercialization, portfolio management, etc., etc. So her she is making use of her extensive 13 years of experience successfully to advise many individual inventors, students, researchers, etc. So she is very passionate in training and teaching. So she is contributing her time as a visiting faculty to D.Y. Patil International University in Pune. So she aims at consistent IPR learning and spreading IPR awareness and importance through her work to the society to enrich our country's business and thereby a nation. So friends, let us welcome Dr. Mohini Suryawanshi. So ma'am, the floor is over to you now to guide all participants about this IPR branding and strategy and legal aspects.
Welcome, Dr. Mohini. Please unmute yourself.
Hello, good evening, everyone.
Good evening.
Yes, thank you very much for the introduction. Could you please allow me to present my screen? Hello, can you hear me?
Yes, yes.
Hello. Yes, could you please allow me to present my screen here?
Yeah, sure.
Yeah, thank you.
Please proceed, ma'am. Please proceed.
Yes.
So meantime, see our guest speaker starts her presentation. I request all the participants, whatever questions or doubts you have got, you can put your queries in your chat boxes. Okay, we can consolidate and speak later on. Thank you. Yes, ma'am. You can continue.
Is my screen visible? Yeah.
Yeah, it's visible.
Okay. Yeah. Thank you very much. So today's topic is branding strategy and legal challenges. First of all, we will see in brief what is intellectual property rights, because branding is nothing but a trademark, and trademark is one of the indispensable IPR, intellectual property right, to run a successful business. So first of all, we will just see what is IPR in brief. IPR is a intellectual property rights. So intellectual property right is given to IP, intellectual property. What is IP? Intellectual property is an intangible property that is the result of creativity, which refers to the creations of the mind of an individual, which has commercial and moral value, such as patents, copyrights. If you take patents has commercial value, but if you take copyrights has got commercial as well as moral value. So IP is nothing but a creation of human mind and intellect. It is given for idea, concept, thought at the beginning. When you conceive some idea, you can protect it under IPR, which is patent law. And it is also given for research and development. Once you conceive the idea, you further have to develop it through your R&D. So it is given for the idea which you can reduce to practice, which you reduce to practice means what you can come up with that idea to the process or product which can be commercialized in the market. The outcome of these ideas may be development of products, processes, industrial designs, trademarks, etc. Businesses of all sizes holds intellectual property, but many business men or women, I would say, don't know that they really hold intellectual property or not. Because this is the reason why, because there is lack of awareness in many of the business community. So though they hold the IPR, they are not well aware what is IPR I am holding to my business and how should I protect it, so that I'll get the exclusive right for specific period of time, and I'll get the monopolized right to reap the benefits of the creation of my intellect. We will see the IPR, type of IPR. So IPR can be patents, trademarks, copyright, design, GI. GI is a geographical indication, and semiconductor layout design is there. For that also, our India provides protection under Semi Designs Act 2000. And further, I'm not able to see here. Further, it is also for farmers, yes, plant variety and farmers, plant variety, protection of plant variety and farmers' rights. So for that purpose also, we have got specific IPR in India. What are the objectives of IPR? We'll see in brief. The primary purpose of IPR is to stimulate creativity by providing an exclusive rights to creative inventions and work. The specific purpose is to incentivize the inventors who really take out their precious time, and they are involved in a lot of R&D and come up with some idea, and then they reduce that idea through their R&D to the final product. So this entire process requires a lot of efforts, human intellect, money, of course, and time. So now suppose one inventor is into the involvement of all these things, and if he is not able to get any right, any protection for that, and somebody else is allowed to use the benefit of his IPR for free, then such person will get demotivated, and he or she has no purpose to further get into the involvement of all these things to come up with some inventive product or process. So for this purpose, what government says that, okay, we will give you specific monopolized right for specific period of time. Let's say for patents, it is for 20 years. For trademark, it is for 10 years, which can be renewed later. So specific period of time, you will get the time. And in terms of that time period, you reap the benefits, having exclusive right. But after that time is over, specific period, like for example, 20 years for patent, then you have to disclose. I mean, it becomes by default disclosed to the community, to the nation, and anybody can use it without the permission of that inventor. So this is the purpose that, okay, government has to take care of the inventors at one side, and government also has to take care of public at the other side. For specific period of time, inventor is given the exclusive protection, but at the same time, when that protection is over, after that specific period of time, then that invention becomes public, and public can take benefit out of that. So that is the beauty, that this is the balance provided by the government in terms of disclosure of your IPR to the government. Now this protection rights inspire artists, because as I said that this IPR is specifically given to incentivize artists in terms of money, reputation, popularity, and this is how it benefits to the society. Now, as I said, IPR is consists of different rights, and trademark is one of the IPR, which is very important in business fraternity. Why? Because your name, your business is identified by some trade name, which you can say a brand name. And brand name only creates the identity of your business in the market in India and abroad. So it's very important to protect your brand name right from choosing it. Very unique trade name you have to choose, and further you have to develop, you have to brand it in a specific and effective manner so that your business will reap the benefits of your trade, of your brand name. So here we can see what is a trademark. Trademark is a brand name, and it can be a name, it can be some term, symbol, design, can be a sign. According to Indian Trademarks Act, trademark is a unique symbol or words used to represent a business or its products. In India, trademark protection is governed under Trademarks Act 1999. Before this act, there was Indian Trademark and Merchandise Act 1958. Later, then we came up with a few advancements in that 1958 Act as we developed as a developing nation, and then we had to come up with this new Act of 1999. According to Section 2ZB of 1999 Act, trademark means a mark capable of being represented graphically, which is a very important feature, and which is capable of distinguishing the goods or services of one person from those of others. And it may include shape of goods, the packaging, and combination of colors. Later, this shape of goods, packaging, and combination of colors have been incorporated in this 1999 Act, which was not there incorporated in 1958 Act. Because of the requirement, the government thought that, okay, we have to amend this and we have to make a, we have to go for a new act, that is 1999. Now, what happens is once you registered some mark, the same symbol or the same mark are not being used by others because that is called violation. Once registered, that same symbol or series of words cannot be used by any other organization forever, as long as it remains in use and proper paperwork and fees is paid. Like as I said, trademark is valid for 10 years of time period initially. And later, after 10 years, you have to renew it. So if you keep on renewing that trademark in the trademark registry, your trademark will get the perpetual rights. It has no it has no limitation, time limitation. It will be forever for your business. And that is how you can create the goodwill and reputation through your brand name. Over time, trademarks become synonymous with company name also. You can see sometimes company name is only the trademark, and sometimes products of that particular company are, having that particular trademark. For example, now you think of the apple shape with a bite taken out that Apple uses its logo. The swoosh logo that Nike features on all of its products, or the girl on the Parle-G packet, these have registered decades ago, and they have built over the time the reputation in the market. How to protect the trademark, we will see in brief, because I don't want to go into deep in this. What we need to do is first, yes. Yes, we will see in brief how to protect it. You have to file it. Though filing is not mandatory, later I'll come to that. But filing of trademark will give you particular rights to avoid trademark infringement. So how to file a trademark? First, you have to adopt a very unique trademark. May it be a name, term, or a logo. And you search it first. First, you adopt some catchy or some unique particular name, which is novel and original. And then you search it in the trademark registry database or internet or market research can also be done. And after that, when you are sure that, okay, this name is not with any other organization, I can safely file it. It can be considered as original or novel by the registry. That time you can file the trademark application, wherein you will get the application number immediately. And after that, the registry will generate the examination report. And to that report, whatever objections are raised by the registry, you will have to reply within 1 month of time period. Further, if required, trademark registry examiner will conduct the hearing if required. Otherwise, without hearing also many times the trademarks are granted. If the hearing is conducted, then there can be two consequences, like trademark can be accepted or it can be refused. If accepted, it will be published in the trademark journal, wherein after publication, any third party can get 3 months of time period, which can be extended further for 1 month, to take the objection on the protection of particular trademark. And once the opposition is filed, then the opposition procedure will be followed. And if no opposition is filed, then trademark will be registered successfully. What are the benefits of registration? Once trademark has been granted, owner receives 3 key benefits. It is the alarming bell. It is a notice of claim to any other businessman thinking of using the same symbol, thinking of infringing your trademark. So it is the alarming bell for other businesses that not to use your brand name, because you have already protected it in the name of your company. It is also a legal presumption of ownership, because you own that trademark after registration, which can help fend off would-be users. And it gives the exclusive right to use the claimed trademark, which further you can commercialize. And you can also reap benefits through licensing with joint ventures, or with different types of joint ventures with other companies, or you can also commercialize it alone. What is brand? As I said, it's nothing but a trademark. It can be in the form of term, symbol, design. Here we have shown few trademarks, popular brands, Coca-Cola, CK, Sign. This one is Nike. Then McDonald is a symbol. It can be a design. Being human is a trademark, which is a design. Here also you can see some famous brands and their symbols. Gucci is there, CK is there, many other are there. What can be the brand strategy? We'll come to the topic now slowly. Brand strategy, why we frame any brand strategy is very important because it creates the reputation of your business in the market. Through your branding, you extend the promise to the public, to the consumers of your product or services, that you are the best organization and you have protected under particular law and you are abide to give the best quality to your products and services through the building of your reputation. So as and when your trademark or your brand will be popularized in any country, you will get more and more, your reputation and quality of your products will be recognized by the association of your business name. It increases brand personality, what you want your brand to be known for. So that is a magical, forceful, etc. So it develops personality also. The brand equipment is there, wherein different colors and taglines, catchy taglines can also be associated with your business so that it will be recognized in a more popular way. Through branding, what you can do is you can also go for co-branding. For example, co-branding is a strategy in which two companies join together to create new product carrying both their brands. For example, Pepsi and Pizza Hut, wherein Pepsi and Pizza Hut has collaborated and they're doing their co-branding together. Similarly, Coca-Cola and McDonald is also the example wherein the co-branding is taken place and they are doing extremely well. Another advantage is you can also go as a national brand product that carry the name of the manufacturer. For example, Haldiram's, Tata, Bajaj, they're carrying their names as national brands. Private brands can also be taken up, product that carry the name of the seller, not the manufacturer. For example, Shoppers Stop is there, West Side is there, and generic brand names can also be there, wherein the brand name over which the original owner has lost his exclusive right. Why? Because it has been used for so long period of time and it has been associated with the particular company, but it becomes generic. For example, Xerox is a company, but Xerox became a generic brand because of its use for a long period of time, and now instead of photocopy we use Xerox. Similarly, Jeep is there, Velcro is there. Now, if we have to brand our companies, products, processes, then what branding steps should be followed? Step one can be you have to learn the market, what is the market objectives which you have at the back of your mind when you are planning to have some brand and when you are planning to coin some brand in the market. So you have to learn the market objectives. You have to prioritize your targeted market. For example, suppose you are planning for some cosmetics brand, then you have to have the brand strategize in such a manner that it should target women, because women is the part of the consumer which who use cosmetics very often. So you have to prioritize targeted market, and then you have to create catchy taglines also along with that, and timelines timelines and budgets you have to create when you are having your brand to be strategized. Then you have to go for particular concepts. It can be catchy taglines, wordmark, catchy designs, which can fetch the attention of the public of particular targeted market. For that, you can have visual search also, and you can have you can have your creative team so that they can frame a very catchy and very unique brand name for you. You can also develop outline and copy points per selected concept, because every concept you have to further evolution, and further you have to explore into that concept, how to make it more catchy through your advertising campaign. Being creating visual materials is very important, because when you advertise it on digital mode or offline mode also, how you present it through photos, colorful photos or layouts, and with comments or catchy taglines, it is very important. And later you have to create with all these layouts and comments, you have to create a full layout or e-design for that. And then finally you come up with the web designing, wherein you can pitch your products to the public on e-platform. Through this, you can have the final execution and management of your products, wherein you can launch your product on the website, and people will start recognizing your product through that. What is the purpose of building a brand? It is, as we have discussed, it is to reap the benefits that a successful brand brings. It can be useful for licensing, because if you don't want to practice, if you don't want to commercialize your product using that brand, of course you can approach to some other business person who want to use it through licensing agreement, or simultaneously you can also use it, and you can also give it its licensing to some other business man, so that you can have licensing out of your brand name. And this way you can earn a smart heavy and good. You can fetch a smart business also, and you can earn a very heavy royalty through these licensing agreements. Now it can also help you in extensions. Example, we have seen McDonald's and Coca-Cola, how they are co-branding and they are extending their business very smartly. And it can also be helpful to you through sponsorship. Like once your brand is very popular in the market and it's well recognized in the public, then it is you can easily sponsor other events through your brand name, and this is how your brand again can become more popular. And you have also you also develop sponsorship capacities also. This all can happen only because of popularization of your brand through your smart brand building strategy. You can also endorse, if your brand is popular, it can also be used for endorsement. And there are certain other opportunities also which you can be it can be reaped by you. Why branding is important? It builds reputation. It gains the public trust, because particular brand is associated with the trust to the targeted market. And it increases down the line when people start using your products or services, and when they come to know that particular quality is associated with your product, then they never change that brand. For example, Colgate brand is there. Many people do use Colgate brand for ages, like because the Colgate has built that brand strategy, and people don't want to change. So this is how you can build a brand for ages through the reputation. Now, what are the legal challenges of non-branding? Branding is very important, we have seen. But when we don't go for branding and we just start using some name blindly without searching in the market or on the trademark registry, and you just adopt some random name and start using it without having any awareness of its legal implications, then what are all challenges you can face further, that we will see in the brief. Brands create personality and a life for your products and services. It is an essential and crucial part of business. So these legal aspects are associated with your brand. That is why it is very important to choose a unique, novel, and original brand name and practice it. There are few aspects which we have to keep in mind while creating a brand. We have to choose very unique, original name for your business, as a business name or products or services for your business. And then you have to make sure that you have to register that name. Do not use it randomly in the market without having any searches, without having any idea that somebody else is also using, or without having any idea that you are intentionally or non-intentionally you are infringing on somebody's trademark. So that is why you have to register it. Make sure that you register it, and when it is novel, original, of course you will get it granted. Because failure to register your brand will lead you to serious legal consequences. Now we have to keep in mind that rights to a trademark are acquired through the use of the trademark, not the registration. Here the use and non-use both are very important. Sometimes registration, as I said in the very beginning, that registration is not mandatory, but registration fetches you certain benefits when it comes to the infringement. When you are into commercialization of your products, then registration of your brand plays a very key role. When there is a phenomena where your brand gets infringed, or you are infringing upon somebody's brand, in both cases registration of a trademark plays an indispensable role. Failure to non-registration of a brand leads to intentional, non-intentional trademark infringement, which is a long legal battle to prove the ownership of the brand. Suppose you have come up with some name in the market and you have not protected it, and you have practiced it for a long time, but after that you come to know that somebody else is already using it, and the person or business, any business which are into that same business of good or services, wherein you are also practicing in the same goods and services, at that moment it leads to the legal battle, because there can be a filing of infringement suits in that case. So what is trademark infringement? We will just see in brief. It's a pure violation of the exclusive rights attached to a trademark without the authorization of the trademark owner or any licensee. So we have to avoid this trademark infringement by properly protecting your brand name. In India, trademark infringement is cognizable offense, which means the infringer has to face criminal charges along with civil charges. Now, in case of trademark infringement or passing off, the court may award the following remedies. The court, for example, party A has filed a suit against party B for injunction infringement. Then court may award to party A temporary injunction or permanent injunction or damages, or account of profits. Account of profits is damages in the amount of the profits gained by the party who is infringing upon. In this case, party B will have to pay account of profits damages to party A, because party B is infringing upon party A's trademark. Now, court may also order for destruction of goods, whatever goods have been manufactured by you under that brand name. So court may order that you just destroy whatever goods are there manufactured by you or sold by you. You just take it back, that goods from the market. So that can also happen. And then you will lead into tremendous economic losses of your business. And the cost of legal proceedings, whatever will take place, that also has to be borne by the plaintiff in that case. So considering the legal implications of branding in an improper manner, what all legal complications can take place, we have seen. Now we will just see, to emphasize on this aspect of legal challenges, few landmark cases wherein you will understand more emphatically what legal challenges can be faced due to non-branding, non-branding of your trade name. There is a case, Coca-Cola Company versus Bisleri International Private Limited. This case is considered as a milestone decision in India's IPR history. The trademark is a unique symbol used to present, as we have seen. Once registered, that same symbol or series cannot be used by any other organizations, that we have seen. Now, as the definition explains what trademark is, the present case is an elaboration to the definition of trademark. If a trademark is licensed by a corporation, no other corporation may use it, or it may constitute an infringement. In this case, Delhi High Court restricted the sale of Maaza product by Bisleri in India, and an interim order of injunction was passed against the defendant company Bisleri, preventing them to use the trademark each purchasable in India and export merchandise also. The plaintiff company was Coca-Cola Private Limited. It suffered a huge loss and injury. But Delhi High Court restricted the sale of Maaza product by Bisleri in India, and an interim order of injunction was passed against the defendant company Bisleri, preventing them to use the trademark each purchasable in India and export merchandise. Now another one is you can see Starbucks coffee and Sardar Baksh coffee. It was deceptively similar trademark adoption case, wherein there are in this case the understanding and the essence of a trademark was reiterated, that it is a unique factor of identification and distinguishment for a consumer and the business in question. The most significant characteristic of a trademark is the goodwill it garners over its period of usage. Starbucks coffee versus Sardar Baksh coffee laid down essential guidelines as to when it can be claimed that one trademark is deceptively similar to another, and the effect that it can have on the business whose trademark has been infringed. So it was a case wherein the trademark was adopted by Sardar Baksh coffee intentionally. It is called an intentional infringement, just to reap the benefits of the original company who has developed their reputation and goodwill into the market over the period of time through their business. And this was the case wherein this is a very significant case. Again, Bharat Pay and Phone Pay is one of such cases wherein in this matter, Bharat Pay had launched their product in the market prior to Phone Pay, right? Prior to Phone Pay. The court ruled that there was no case for grant of interim injunction against the defendants. The court observed that except for the common word pay was the suffix to Bharat and phone. It cannot be established that the marks Phone Pay and Bharat Pay are confusingly or deceptively similar. In this matter, Phone Pay had started using that brand name, but they had not registered it. So Bharat Pay was using their brand name in the market in the course of trade, but they had not protected it under Trademarks Act. And when Phone Pay had not protected it. And when Bharat Pay came up with the same concept, and Bharat Pay also started commercializing in the trade with the Bharat Pay name, that time Phone Pay was a plaintiff. Phone Pay had approached the court saying that Bharat Pay is using our brand name, which we have already built in the market, and they are using our same suffix which we have used, PE Pay. So in that matter, because Phone Pay had not registered it, it went to the passing of action, and then court said that pay is not a unique word. It's just a misspelling of PAY. So it's just a misspelling of PAY. It's not any unique word which you have come up with. That's why the pay cannot have exclusive right. Pay cannot be given exclusive right for you, and it is a very common word. That's why then Phone Pay had lost, and Phone Pay incurred huge losses through this. The court observed that except for the common word PE suffix, it cannot be established that the marks Phone Pay and Bharat Pay are confusingly or deceptively similar. But in this case, if instead of pay there was any unique word which had been adopted by Phone Pay, then this case could be won by Phone Pay. But in this matter, pay was not any unique word. That is why barring the suffix pay, there are two different words altogether with no commonality whatsoever. So pay was only the common word which was also not unique. And that's why the judgment serves as a primer on all things on trademark law and illustrates various legal principles, especially on trademarks law. So in this case, we can see that only because of non-registration of your mark, though you have started using that mark in the market, and also it had lacked some unique features, like it was not coined, it was just a misspelling. That is how PhonePe had incurred a huge loss. It shows that it's very, very indispensable to register your mark before you practice it. It's very important. Another very popular example, you can say it's very significant in the in the industry. ITC Limited versus Nestle India. Here in this matter, the matter was about one tagline, magic masala. So magic masala was the word, and it has been used by the ITC. Yeah, ITC had started using it in 2010, and they had into advertising also using the word Sunfist Yippee noodles. Sunfist Yippee noodles was the product of ITC, and yes, and magic masala are the common words they were using, but they had never advertised magic masala words with their products. And later Nestle came up in 2013 with magical masala, and they had started advertising with magical masala tagline. And when the sale of Sunfist was going down, then this ITC went to the court, and then they said that this Nestle is infringing upon our trademark. In this matter, again, same case, that ITC is an Indian company which had not registered their trademark, first of all. And secondly, we can also establish trademark by use. But in this matter, what they had done is they had not advertised their brand Sunfist Yippee with this tagline of magic masala. They skipped that magic masala and they just advertised with Sunfist Yippee noodles. And also court had seen that two aspects in this matter, wherein your brand, ITC's brand, was not registered with trademark registry, and secondly, they could also not establish their prior use in this matter, though they were using since 2010. But the court said that yes, you had advertised, but you had not advertised magic masala words. And now Nestle has come up and they have started using magical masala on their packet itself. And this is how a very good example which we can learn through that registration of your brand is very, very important. So in this matter, court held that it was a legitimate adoption by the defendant. In this matter, Nestle was defendant, as no person can appropriate generic or laudatory words, and such words cannot be monopolized or protected by the courts. Here, magic masala was the laudatory word, which is praising your product. So court said that such words are not allowed for protection. And the court also referred section 9(1) of the Trademarks Act, which prohibits the registration of these generic marks. So this is a landmark case in the history. Furthermore, the court also held that plaintiff had used the phrase magic masala in a laudatory way to complement the masala, and it was never used as a sub-brand or trademark, because they had just concentrated on Sunfist Yippee noodles, that's it. So this is how they lagged behind in their advertising branding strategy here. Court held that magic is not a distinctive term, as it is very common to the food industry and cannot be said to distinguish the noodles sold by the plaintiff. Moreover, there is no case of passing off, as there is no ocular or visual similarity between the wrappers of the noodles sold by the two labels. Now, because it was not registered, they couldn't establish their prior use also, and it went to passing off. Passing off is it's a trademark. When you're not registering it, you are not authorized to file infringement suit for your trademark, and then you have to go for passing off action. And in this passing off action, you have to prove to the court, based on three principles of passing off, that the defendant has misrepresented your mark, or defendant has damaged your goodwill which you have earned over the ages or over the period of time by use of your mark. And this damages also you have to show in terms of sale, profit and all, losses, profit. So all these things couldn't be established by ITC in this matter. We have seen few landmark cases. This is the conclusion, right?
Yes.
Yes. So we have seen the few landmark cases in this session, wherein I hope I have just given insight of in a very short span of time what is branding and how to protect it. What all are the legal implications of non-branding of your trademark. So conclusively, what we can say is building an exhaustive branding strategy and registration, which is very important. I emphasize registration of the brand is the only key for successful business. Due to ineffective branding strategy, which leads to non-recognition of business in public and non-building of trust and positive reputation of the particular brand in the market, and thereby incurring huge economic losses. Therefore, it's very important to have effective branding strategy, exercising it in the consumers, and build your positive reputation. And ignorance to building an effective branding strategy and non-registration of a brand will lead to huge monetary and defamatory losses as well. The businesses will have to face severe legal consequences. We have seen few here due to intentional and non-intentional trademark infringement of registered trademark owners. Last slide. Last slide. Last slide is there. Okay. Okay. So this session, yeah. Last slide. Just a moment. Yeah. So this is where I would like to stop my presentation. If any queries, questions are there, are welcome. Thank you very much.
Thank you, ma'am. Thank you so much. Very nice topic today. We explained about brand strategy and the legal aspects rather. So the legal aspects were so important for our brand name, brand style, brand monogram, whatever it is. So friends, I hope this session was very useful for building your brand. Basically, before you establish your brand, you have to take so many precautions as such. As rightly ma'am has explained, legal aspects were very, very important. So I'm surprised such a big companies are making mistakes, but it is a very, you have got an opportunity to understand. See, ITC is making mistake. So many big companies, they have made a mistake not by not registering their brand names, brand lines, taglines, whatever it is. So I hope this session was very, very useful. So we'll continue such topics every fortnight under Industry Insight platform through our FIIP. So FIIP has got so many platforms as we shown in the beginning, networking, business spot, Industry Insight, what we are today going through. Then there is a womanpreneur, there is a platform for youth. Of course, another platform we have started, NavUrja, which is addressing so many social and environment issues. There is a business kata to gossip on business contents. So friends, if you want to connect with the FIIP, definitely you can connect. We have got Business Spot is our platform where you can initially connect with us. So can we show the link for connecting our audience? So this is our link for getting connected to Business Spot platform, and there is a QR code also. You can just scan it and fill the related information. So this is just for information, and we'll get into some question answer session. We have got some queries also. Before I get into a question answer with all of you, I request our founder member, Mr. Navnath Devkar, to speak few words on this FIIP and this platform. Over to you, Navnath, sir.
Thank you, Sivake sir. It was a very wonderful sessions, Dr. Mohini ma'am. आपने काफी अच्छा सेशंस यहाँ पे लिया है आज का, और आपने सेशन में जितने भी टॉपिक्स लिए वो एवरी बिजनेसमैन के लिए काफी इम्पोर्टेंट है। हम लोग बहुत बार देखते हैं कि हमारा बिजनेस हम लोग चालू करते हैं, और बिजनेस चालू करने के बाद एक पॉइंट पे हम लोग का बिजनेस का एक पॉइंट पे आता है कि जिस पॉइंट पे हम लोग सक्सेसफुल के टॉप लेवल पे होते हैं, लेकिन हमारी जो प्राइमरी वर्ड्स है, जो बिजनेस का ब्रांडिंग है, वो ब्रांडिंग अगर कोई यूज करता है तो हमारे बिजनेस में इन्फ्लुएंस क्रिएट होता है, हमारा बिजनेस कोई टेक ओवर कर लेता है हमारे नाम से, और ये आपके बिजनेस का बहुत ही बड़ा लॉस है, बहुत ही बड़ा लॉस है। ये लॉस अगर हम लोगों को रिकवर करना है तो हम लोगों को हमारी जो असेट है, हमारे बिजनेस में जो भी असेट्स हमारी बनती है, फैक्ट्री है, फैक्ट्री के साथ में मैन पावर्स है, मैन पावर के साथ में हमारा डाटा है, डाटा के साथ में हमारे कस्टमर्स है, क्लाइंट्स है, इसके साथ साथ में हमारा ब्रांड भी हमारा सबसे बड़ा असेट है, और ये असेट को हम लोगों को प्रोटेक्ट करना है। अगर हम लोग उसको प्रोटेक्ट नहीं करते हैं तो यस, आगे जाके आपके बिजनेस में प्रॉब्लम्स आने वाला है। सो डेफिनेटली आज के जितने भी ऑडियंस हैं, किसी को भी अगर कोई भी डाउट रहेगा, हम क्वेश्चन आंसर्स तो लेने वाले हैं आगे जाके, लेकिन उसके बाद भी अगर किसी को लगता है कि मुझे प्रॉब्लम्स है, मुझे ब्रांड के बारे में समझ के लेना है, मुझे ब्रांड्स के बारे में और ज्यादा इंफॉर्मेशन चाहिए, मुझे उसके लिए कोई हेल्प करेगा क्या रजिस्ट्रेशन के लिए, तो यस डेफिनेटली हमारे जो स्पीकर्स है डॉक्टर मोहिनी सूर्यवंशी जी, वो आपके साथ में है। डॉक्टर मोहिनी, मैं आपको रिक्वेस्ट करूंगा कि आपका कॉन्टैक्ट नंबर और ईमेल आईडी आप चैट बॉक्स में डाल दीजिए, ताकि जितने भी ऑडियंस है उनको आपके पास रीच करने के लिए वो एक मीडिया है, कॉन्टैक्ट नंबर और ईमेल आईडी, उससे वो लोग आपके साथ रीच कर सकते हैं। सो थैंक यू मोहिनी जी कि आपने आज यहाँ पे काफी अच्छी तरह से एक्सप्लेनेशन किया है कि ब्रांड वैल्यू क्या होती है, उसको प्रोटेक्ट कैसे किया जाता है। सो आगे हम लोग ऑडियंस की ओर जाएंगे कि जो भी क्वेश्चंस है, क्वेश्चंस के ऊपर हम लोग जाते हैं। सीबीके सर, मैं आपको रिक्वेस्ट करूंगा कि चैट बॉक्स में कुछ सवाल आए हुए हैं, सो उसको कंटिन्यू कीजिए।
ओके, थैंक यू नवनाथ जी। फ्रेंड्स, अभी हम सवाल जवाब करेंगे। देयर आर सम क्वेश्चंस। एक बहुत ही अच्छा सवाल है, इनफैक्ट दो सवाल है मिस्टर प्रसाद सावले जी से। तो पहला सवाल है उनका, हाउ डू वी कम टू नो दैट आवर ट्रेडमार्क टैगलाइंस आर यूज्ड बाय समवन? इज देयर एनी सिस्टम और एनी ऑटोमेशन फॉर दैट? सो दिस इज व्हाट हिज फर्स्ट कंसर्न। तो दूसरा सवाल है वैसे रिलेटेड है, वेयर डू वी हैव टू सर्च इन द डाटाबेस दैट आई एम नॉट यूजिंग एनीबडीज नेम? यानी वो वाइस वर्सा पूछा है कि मेरा जो ब्रांड है, मेरा टैगलाइन है, या मेरा जो भी ट्रेडमार्क है, कोई यूज नहीं कर रहा है, वो मुझे पता कैसे चलेगा? या मैं किसी का यूज नहीं कर रहा हूँ, ये मुझे कैसे पता चलेगा? तो बहुत ही अच्छा सवाल है। मैम, ओवर टू यू।
Yes. When you have to adapt some name, you have adopted, first stage is you have adopted some unique name. Now you have to search it. You can search it in 2-3 ways. You can either go to trademark registry website, ipindia.nic.in. In that you can go to trademark session, and in trademark there is search, public search is there. In public search you can go and you can search your trademark under, there are two searches, phonetic search is there and word mark search is there. So you can search under both. I would suggest you to search under phonetic searching, because phonetic searching will allow you to fetch all those trademarks also which are deceptively similar or very closely similar and identical also to your brand name. So you can go in trademark registry or site in public search, and you can put your whatever is your brand name which you want to adopt, and then you can get the results. All results you will get. This is one way. Another way is you can go to web and you can search that way also, because there are many companies which use trademarks but they don't register it, maybe due to unawareness or whatever can be the reason. So maybe they don't feel that it is very important to register, and when they get entangled in some litigation, that time only they come to know, okay, this was so important, and I skip that part. So this is how which company, few companies are there which are using trademarks, but they don't register. Then when you search in trademark registry site, you will not fetch those trademarks which are not registered, but still somebody is using it. So you can go on web also, and through internet search also you can fetch those trademarks which you think that they are overlapping to you. And based on that, you can make the strategy whether to adopt your name, or you can modify it so that you cannot infringe on whatever existing searches you get the results. So that way you can adopt it. So this, I think this is I have explained it. Yeah. And the same strategy you have to adopt, where there are two questions, right? How to what is it? Do we need to register trademark in, okay.
This is second next question. No.
Yes. How do we come to know that our trademark taglines are used by someone? Same way, you have to go in this both ways, and you can find it. Once you are confirmed that, okay, you're not infringing upon any existing brand name, then safely you can register yours and then you start using. Or even if you have started using, you can claim the prior user by filing affidavit and proofs of your use, and then safely you can claim the prior user date also when you are filing it later than your actual use. That way you can do.
Okay. Thank you, ma'am. Thank you. Just connected to this only. Suppose I have some brand name and it is already existing during our search. If we find somebody is using but not registered, okay, but we are also not registered yet. If we register prior to them, okay, is that okay? Can we claim our rights on that?
No, in that case, what happens, we have seen in our presentation, passing off is something wherein the person who has not registered, that person can come later and he can file suit against you under common law. Though he is not authorized to file infringement suit against you, but he can file case against you under common law, saying and proving that he has been using it from long time. So it is also unsafe. It's not recommended to do that.
Okay.
If you find that somebody else has adopted it but not registered, then also you can modify your trademark which you are proposing to use, and then you can register it, and then safely you can commercialize it.
Okay, got it. So if we are older than him and we can register first, is that okay?
Yes. If you are if you are using, like for example, you are using from 2000, and the other company which you find that it's using from 2015, for example, or 2004. In that case, yes, of course, you can file the trademark with prior user date, and later you can stop that other company from using your trademark. Yes, it's possible.
Thank you so much, ma'am. Hope Savaleji, I think you got your answer. So the next question is from Makarand Velenkar. Do we need to register trademark in other countries also if we need to sell our product in those different countries?
Yes, definitely. You have to do that.
Okay.
Because these IPR rights are all territorial rights. If you protect your right in one country, doesn't mean that you get that right in other countries as well. Wherever you want to take protection in all those countries, you have to go and you have to protect it in those countries. Whether it's patent, trademark, any IPR, you have to protect in that particular jurisdiction wherein you will get the right. Otherwise, you cannot claim or you cannot stop that person from using your mark, unless it is very popular brand like Mercedes, or unless it is a very popular mark, then only it's possible. Otherwise, it's not. So it's always recommended, wherever you want to commercialize your product in any country, you have to go there and you have to file it. There is also Madrid protocol through which you can file international application, and for the at that time only you can select few countries of your interest and you can file it through international system of Madrid protocol. So it's a safe, you can protect it.
Okay. Thank you, ma'am. Hope Makaranji, you got your answer. Prasad has just raised, it is not a question exactly, but he's asking some clarification. When such during your presentation, you quoted a few examples of big brands like ITC and all those things. So when such big companies are making such mistakes, okay, they are taking, though they are having some legal department, all those kind of things, how a small company or startup company can protect themselves? Matlab, does this company need to have a legal team exclusive because it's being a small company, a startup company, okay, or instead, what should be that way out to have that competency for this small organizations?
Yes, yes, it's not always mandatory to have legal department when it comes to a very small company, and a legal fees, it's very huge. Every startup company cannot afford that payment and other things of a legal department. So it's not absolutely mandatory for them to set up their legal department. But yes, you can approach to some IPR attorney, and you can definitely form the strategy, and through that strategy you can file it, wherein you will get the proper legal guidance, and then your trademark will be granted successfully, because the attorney knows how to deal with all the objections of the trademark office. And before filing also, what all knowledge is required to select that particular brand, that also can be advised by that attorney. So it's always recommended to approach some IPR attorney who is having that related knowledge, and to go through such attorney to get a successful registration. Absolutely no need of a legal department to set up.
Okay. So one more question. वेबसाइट के लिए डोमेन नेम रजिस्टर हुआ है तो क्या ट्रेडमार्क रजिस्टर करना जरूरी है क्या?
Yes, of course. Your domain name is registered. For example, FIIP.com is your domain name, but that domain name you have you have purchased on so and so date. So even you can show that, okay, I have purchased it on 1st January 2020, for example, and taking that priority also, you can claim the word mark, because you have started using. If it is an incorporation of some company and you select the name of the company before registration, for example, a private limited company is there, and you have come up with FIIP private limited, for example. So that incorporation certificate also you can use to claim your prior use of that name, and with that prior user date also you can register it. So of course, domain registration is altogether a different thing, and trademark register is altogether a different IPR protection. Both are different, but you can link it to create the user claim. Yes.
Thank you. Hope Sandeep ji, you got your answer. जैसा वेबसाइट के लिए आपने डोमेन खरीद किया तो आपका वो डिजिटल प्लेटफॉर्म के लिए आपका नाम है वो रजिस्टर करना लेना होता है, बट ये जो लीगल एस्पेक्ट फॉर ब्रांडिंग है जो मैम बता रहे हैं, तो फिर भी आपको ये आईपीआर के अंतर्गत आपको रजिस्टर करना जरूरी है. ओके, थैंक यू सो मच. आई थिंक चैट बॉक्स में से क्वेश्चंस हो गए हैं. If somebody still wants to have some queries or questions, you can raise hand and directly ask questions. Otherwise, we'll go for next this concluding session. Anybody else?
Yes, I have a question.
Yes, please.
Mohini madam, that was really fantastic presentation and a lot of information. I have a lot of questions in mind, but they are all clear. So, I have already have one registered trademark in India. Now, to get that registered trademark abroad, as you already answered for that, but country-wise, how I can apply for that and how much time is needed for that to get the international registered trademark? Because and if somebody have the same name outside India, so how we can prove that my registered trademark is older than his registered trademark, and so how much time is needed for all this procedure? Because getting the trademark internationally is little bit more tedious job, I think. It's not easy compared to the trademark, which is the time needed in India, what I feel. So is it right? So How we can get
No, it's not at all complicated. As we have explained, like a Madrid protocol is a process wherein you can file international application, and there is a provision that you can also claim priority. For example, if you have filed Indian application and within 6 months of time period you are going in the country of your interest, let's say Japan, then you can file international application, and in that application only there is a provision that you can claim your priority from India. So if you claim that priority, then in Japan also you will get the priority date. Like 6 months back, you can claim that and you can file it in Japan. This is the answer of your first question. And second part of your question was, suppose somebody else has already the brand name in that country, and you also want to go with the same name, then that will not be allowed, because then it will be the infringement of that prior registered owner, right? So he will not allow you to do that. Even if you filing cannot be stopped by anybody can file it. But when it comes to the objection examination stage, then that would come in the examination report, wherein that another company who is already registered with that brand name in that particular country will definitely try to stop you. And not directly, but in the examination report itself, it will fetch by the Japanese registered trademark office that, okay, this so and so person is the owner of this brand, so you are not allowed, and it will be rejected by the trademark registry itself of that particular nation. So you cannot do that.
Yeah, but how much time if needed for particular international approximately?
Yes. For example, if you are filing your application through Madrid protocol in US, then there is possibility that within 2-3 months also you will get it granted. So our few trademarks have got granted within 2-3 months of time period also in US PTO, in Europe also. It's very fast process. You will not you will not have to wait for a long time. And again, one more thing is that in case of all IPRs, like patents, trademarks, copyrights, and designs, one thing is very important, and it's a beauty of IPR that you need not to wait till grant of your patents or trademarks or copyrights or designs to practice it, to commercialize it. The moment you file it, you can start commercializing it. So again, you need not to wait for its grant. Even if you file trademark, you need not to wait for its grant. You can start using it. If for patent also, same thing is there. So this is the beauty of IPR, because grant process may take a long time also, based on the chronology of the application of that particular time span. So in that matter, it might take a lot of time for grant. So the IPR rights is given as you file it, you can practice it. So that way you can reduce the time, and in other countries, absolutely there are not much time is required. Yes, we have got granted within 2-3 months of time span also in Europe, US, and other countries.
Thank you. But related to that, I have a really small question. Now in India also there are class 35, 37 of categories. So the same category class numbers are internationally approved, or they are different? Means
Yes.
if class 35.
Yes.
Okay. So everywhere the class 35 is having the same category, right? Means that is important.
Yes, because India follows NICE classification, and NICE classification is the international trademark classification which all countries have to follow. That's why our classes, we have 45 trademark classes, out of which 34 classes are product classes, and 35 to 45 classes are service classes. So same pattern and same NICE classification is followed by India and other countries also who are into this trademark regime. So absolutely all classes are same, no change, because ultimately we have to comply with other countries also. That's why it's kept uniform for all countries.
Thank you. Thank you. Thank you. Thank you.
Thank you, ma'am. Thank you. I think one more hand is raised. Before that, there was one small query. If a company is registered under MSME, so does it have any special benefits for under this IPR Act? That was question.
Yes. If company is MSME registered, then under Patents Act, yes, benefits are your fees is reduced, almost 80% fees reduction is there, wherein for a normal company, patents filing is 8,000 rupees. So for MSME, it is just 1,600 rupees. So
Oh.
this is applicable for everything. Like for examination request, for normal person has to bear 20,000 rupees, whereas MSME will have to bear only 8,000 rupees for expedited examination, and for normal examination only 4,000 rupees. So these benefits in fee structure will be given by IPR. And as far as grant benefits are being given, the MSMEs and startups are allowed to file their application for expedited examination, wherein your application will be granted within 1 year of time period. Within 2-3 days also examination reports are generated in few cases. So they mandatorily, within 1 year of time span, they have to grant your application in terms of grant process. Considering trademark, again, same thing, normal company will have to bear filing charges of 9,000, whereas MSMEs will have to bear 4,500 rupees. It's 50% cut down of your, fee structure. And then you will get such benefits for design also. So you will get such benefits in terms of fee structure and grant stages also.
Great, great.
Yes.
So we have got benefit on time and cost, both sides.
Yes, both, yes.
Good, good. Yes, Prasad ji, you have got some question. You raised your hand. आप unmute करिए प्रसाद, unmute yourself. हाँ, हाँ जी. Okay, go ahead. Prasad, can you hear me?
Hello, can you hear me?
Yeah, yeah. Yes, yes.
Okay, so it was a nice session. Thank you so much. Hello.
Thank you.
Yeah, yeah.
Ma'am, I have a question. Particularly if we have brands, taglines, jingles, colors that needs to be trademarked. So can we go, one go and register it, or we will have to do it individually?
You were not audible properly.
हाँ, आप
Please
दोबारा
come again.
पूछेंगे आपका सवाल. आप अनम्यूट करिए, दोबारा आपका सवाल पूछिए.
मेरा सवाल है, हेलो,
आवाज आ रहा है सर, आप बोलिए.
आ रहा है. आपका दूसरा मोबाइल चालू है कि बंद कर दीजिए आप.
आवाज आ रहा है सर, आपका बात कीजिए आप.
Someone's mic is on.
Yeah.
I think he is asking about the brand, which is a brand with logo, tagline, name, and everything. You have to go for separate trademark registration, or the name. That is what is asking. I think so. Is it right?
Okay.
अच्छा.
Yeah, I got it. Yeah. So this is a very common question. Because sometimes the trademark is just a brand name, okay, and sometimes it's just an image, or sometimes it's a combination of name and image. So it's called composite trademark. So there you have got options. If you have to go for word mark, there are two types of marks: word mark and device mark. Device marks means logos, images. And a word mark is one word, any word or with tagline, you can protect it under word mark. So two types of protections you can take. If you want to protect word mark, for example, Spotify, if you want to protect Spotify name, so you can file that name under word mark option while filing your application. And now you have got also Spotify name along with some images, and you want to protect the entire representation. So in that case, you can file it under device mark application. And both applications will go parallelly. Of course, different fees you will have to bear, though they were different applications. But in that case, you have option that you can protect your word mark as well as your that word mark along with the entire presentation with the images. Both options you can take. We suggest to our clients to go for both registrations, because word mark will give you exclusive right over your word. If it is coined word, then you will get the exclusive protection over your coined word. And logo will give you the protection over your entire presentation. So we suggest to go for both kind of protections to frame a effective branding strategy wherein you can stop others from even using Spotify word from using by filing a word mark, and the same representation also which you have secured cannot be filed by others. So both ways you can protect. It's your choice how effective branding strategy you want to adopt for your business. Yes.
Mohini ji, I have one question. Here is Dr. Mohite.
Oh,
Yeah.
okay. Yeah.
So a small question to you. We have seen, I have just heard a very beautiful presentation, no doubt of it. The design, product design, when any company goes for a product design, so how way the design playing a vital role in entire basically registration. As you know, I have seen number of cases in the market. Those people have innovation towards design of that particular similar product, or you can say the same, you can category product, but having innovation, having the research in it. But monopoly, which earlier concerned designer is having of that product in the market, like automobile and many more like cases are there in the market. But what is your suggestion to such entrepreneurs here or such business people here, how they should basically think about the designing their product under this particular registration and registering legally process? Yeah. Over to you, ma'am.
Okay. Yeah. See, design can also be protected under trademark, as we have seen. So designs are also protected. But when it comes to aesthetic look, when you want to protect the aesthetic look, extraneous look, the shape of your product or color combination of your product, that time you have to go for design registration of your product. For example, this is a bottle and it has got unique shape. What you can see, it is the aesthetic look. So what all are the curvatures, all external features of these bottles, irrespective of its use, irrespective of its any inventive feature. If you have to protect, then you have to protect not under Patents Act, but under Designs Act, where your lines and all features, colors of your products are protected. But when you have to protect under trademark, that time there are limitations wherein design packaging of your design is a part of design registration. We have seen in the definition of our trademark in the slide that yes, packaging of your trademark is a subject matter of trademark registration. You can protect packaging of your trademark under trademark law as well.
As we see that patent, now the patent and registration, so what they basically play the role from legal perspective, ma'am? Can you focus on that?
Patent and registration means, sorry, I didn't get.
I mean to say, if somebody wants to have his patent, he has innovated and he's registered for the patent right now. So that way patent and intellectual property, that way it is, some people have the confusion that is it different or it is the same one? Intellectual property and patent, what is the difference in that? Is there any difference or it is the same one? Because one of my questions friend has asked me on my SMS. Okay.
No, actually intellectual property rights is it's a bundle of rights, and patent is the major IPR which can fetch more revenues in the market because it's a very expensive affair, patent. So patent is one of the intellectual property rights. Along with that, copyright is there, design is there, industrial design is there, what I have explained now. Copyright is there, then trademark is there. So these are all different types of IPRs which are bundled together under this term IPR, intellectual property rights. So patent is nothing but it's a part of, or it's a one type of IPR, which is only for invention. When there is invention, when you come up with some idea, conceive some idea, and when you develop it and comes up with some product or process, then you will get the patent for that invention.
It is good for the startup. It is good for the startup. Rather, startups are basically, working in a larger scale in a patent, right?
Yes. For startup, for any of their novel ideas and all that, we protect it under Patents Act.
Thank you. Wonderful, man. Thank you very much. Mm.
Okay.
Madam, I have another question, a simple question. If I want to sell my trademark to any another company, is there any legal procedure for that, or the mutual with the mutual understanding with both the companies, they can sit and they can some do agreement or something like that, and which will or any standard procedure for that if I want to sell my trademark to another company?
Yes, definitely there is legal process, because you cannot sell any of your rights without getting into any legal aspect. What you can do is, when you want to sell your trademark, you have to assign it. There is a term called assignment of your trademark. We make one assignment agreement, and that agreement we have to exercise, and we have to take signatures of both the parties based on the terms and conditions. Like for assignment, how much amount or what is the costing, what is decided in between both the parties, and considering all those aspects which are mutually agreed upon in between both the parties, we jot down all the terms and conditions, and we frame that relevant agreement for assignment of your trademark, and then we can assign your trademark to the company to which you want to sell your trademark. And when you sell it off, the assigned agreement also, you can register the same assignment agreement with trademark registry as well. So the trademark registry will also have the information, okay, this trademark was registered in the name of some owner, and now it has been assigned to some other owner. So ownership is changed. So for that, the same assignment agreement you have to upload on trademark registry, Indian trademark registry as well. So the trademark registry will also be aware about this fact, that this has been assigned, and this has been then displayed by the trademark registry as well, that previously the owner was what, and what all changes have been done. That will be displayed, and you will also have that agreement executed in between the parties, and then the selling process will be completed. Yes.
Thank you. Thank you.
थैंक यू मैम. वन मोर क्वेश्चन, आई थिंक संदीप मोहिते जी, आप अपना सवाल पूछिए.
थैंक यू सर. बहुत ही अच्छा सेशन रहा है. मेरे क्यूरी है कि मैंने आपने पूछा था कि वेबसाइट का डोमेन के बारे में, यदि मैंने एक यूनिक नेम लिया और वो मैंने डोमेन रजिस्टर कर दिया, तो इसका मतलब है कि और किसी का वो नेम नहीं है, ठीक है. फिर वही नेम मैं अगर कंपनी एक्ट अंडर रजिस्ट्रेशन के लिए देता हूँ तो रिजेक्ट होता है. इसका कारण क्या हो सकता है?
Yes. Company Registration Act is linked to Trademark Act. So what happens many times for company registration, we propose 3 names, for example, and then you get the rejection from the company, from that authority who is into the granting process. They say that, okay, you cannot take this one. You cannot take this one. Why? Because they have to check in the trademark registry if any similar trademark has been taken by any other trademark user. So that is a process they have to follow. And when they find that any similar or deceptively similar or identical trademark has already been used by some of the users which are on the trademark registry, then they take the objection, and then they send you that okay, you cannot use it, you change the name. So it happens many times, and they suggest you that you cannot take this name because trademark has been taken by somebody else, or your trademark, whatever you are suggesting, is overlapping with the existing one which are already there with the trademark registry, and they suggest you to come up with something new or something modified version of your brand name which you want to adopt, and then that will be granted by the ROC. Okay, so that process, they both Companies Act and this Trademark Act are linked, and it happens. But nothing this similar combination or similar relevance or connectivity is for domain registration. So domain registration is altogether a different thing. Many times we find that for domain registration, if we go, somebody else has already used it in some other country, and then they want you to buy that and all that. That is a different story. But in India, as this Company Act and Trademark Act are connected, that's why Company Act will not allow you to take any of the brand names which are already there existing and adopted by somebody else. There is no such connectivity with the domain name. So you can take it if it is available globally and no other person from other countries have taken it. If it is taken by somebody else, then also then domain will also will not be registered, because then they will say that this is not available. Then you further, if you want the same one, then they can keep it for sale, and there is further 5-6 months process is there. If you want to take the same brand name, for example, FIIP.com is not available and FIIP.co.in is available. Then FIIP, you can contact to the owner who has taken this FIIP.com, and you can have that negotiation or whatever is your communication, and that person can sell it off to you at a very huge price. So that is also nowadays it's also business, that few people will come up and they secure 5-10 domain names, and when somebody comes up, then it's not available. Now what that person will do, he wants that particular name, so what there is no other way for him to adapt it but to go to that owner of that particular domain name and then have some negotiation and to buy it. Recently one of my clients has bought it for 2 lakh rupees. So this is also a new emerging business nowadays. So I hope you have got the answer for your question.
इसमें मोहिनी जी एक सब क्वेश्चन है कि वाइस वर्सा, अगर किसी ने इसका पेटेंट लिया हुआ है, मान लीजिएगा FIIP या FIIP ये वर्ड का पेटेंट लिया हुआ है, और कोई किसी दूसरा पर्सन ने उसका डोमेन बाय किया हुआ है पहले से, सॉरी पेटेंट की जगह पे मैं ट्रेडमार्क बात करूंगा कि FIIP का ट्रेडमार्क लिया हुआ है, वर्ल्ड ट्रेडमार्क, और पहले ही किसी ने अगर उसी का वेबसाइट रजिस्ट्रेशन किया हुआ है, डोमेन रजिस्ट्रेशन किया हुआ है, तो उस केस में वो डोमेन को जिसने ट्रेडमार्क लिया है वो क्लेम कर सकता है क्या?
I will repeat your query that somebody else has registered FIIP.com as a domain name and somebody else has taken a FIIP registered trademark.
Yes.
Is this your query?
जिसने रजिस्ट्रेशन किया है वो FIIP.com का या FIIP.in का जो डोमेन है उसको क्लेम कर सकता है क्या? ये मेरा सवाल है।
नहीं कर सकता. As I told you, there is no link.
नहीं, मेरा सवाल अलग है। मेरा सवाल ये है कि FIIP इसका ट्रेडमार्क किसी ने लिया हुआ है, XYZ पर्सन ने, और ABC पर्सन ने पहले से ही FIIP.in या FIIP.com इसका डोमेन बाय किया हुआ है और उसके कस्टडी में है। ओके, अभी जिसके कस्टडी में, जिसके पास डोमेन जिसने बाय किया हुआ है, उसके पास उसका ट्रेडमार्क नहीं है। ओके, अभी जिसने ट्रेडमार्क लिया है वो उसको क्लेम कर सकता है क्या? ये मेरा सवाल है।
नहीं, ट्रेडमार्क वाला नहीं क्लेम कर सकता है। Why? Because this he has got only trademark protection, right? And this domain name person has not got any protection under trademark either. So that domain name he has purchased, for example, from GoDaddy. He has purchased it from GoDaddy. It has no link to this trademark registry. So that's the reason the trademark owner of FIIP cannot claim and claim the use FIIP.com from the FIIP.com owner.
Actually, trademark अगर जिसने लिया है तो वो उसका प्रॉपर्टी होता है ना, तो दूसरा किसी ने यूज नहीं करना चाहिए।
नहीं सर, दोनों अलग अलग है ना सर। व्हाट
अलग नहीं है, FIIP जो वर्ड है इट्स अ ट्रेडमार्क, किसी बिजनेस का ट्रेडमार्क है, राइट? अगर वो ट्रेडमार्क कोई दूसरा आदमी यूज करके अगर उसको मिसकॉन्सेप्ट मार्केट में लेके जाता है तो वो ट्रेडमार्क का राइट्स का मतलब क्या बनेगा फिर?
नहीं, बट दिस ट्रेडमार्क एक्ट यू आर प्रैक्टिसिंग, अभी आपको ग्रांट हो गया ट्रेडमार्क एक्ट, राइट? लेकिन once you frame some mark, then only you will go and buy the domain name, right? ऐसे randomly you don't go and buy the domain name. Coincidentally, it can happen that FIIP.com has been bought by somebody else, but then the person having FIIP trademark owner cannot go and sue him or cannot take any legal action against him. Yes, he can go and negotiate that, okay, now I have got this FIIP trademark registered in my name and I want to adapt.
Negotiation नहीं होता है।
Just to sorry to intervene actually, but just I want to add one more angle to this question actually. So if say suppose Navna sir has taken the trademark of FIIP, this word, right? Okay, so he has the rights to use that word exclusively. And then I come into the market, I start the business with this FIIP.com domain, and I am actually doing the business with that name, which means I am generating revenue with that name. Okay, so it is fair, or is there any chance that Navnath sir will come and he will object me to stop from generating revenue by using that name? And I'm using
Yes.
that name maybe in multiple ways, like for branding, putting it on my products, having website under that name, or so any kind of use of that name. So uh, explain this situation now. I want to say actually.
Yeah. In this case, if Navnath sir can, establish that he has taken registration of his trademark and he has been using it, use also you will have to show. There is a provision in Trademarks Act. If you are granted a trademark and you're not using it for consecutive for 5 years, then your trademark will be cancelled by the trademark registry. So Navnath sir has to come up if he acknowledges that somebody is creating revenue in the name of FIIP.com, whatever, and if he can show the prior use of his trademark in the market, then definitely he can take some legal action. These are all intricate situations, and they differ from situation to situation. So many times there is no straightforward answer for many things. Yes, in this situation, he can definitely go and sue that person based on his prior use. He'll have to show the proofs that he has been using this so and so name, and it's been granted to him. Yes, he can do that in that case. But only he has taken it, got granted, and he's not been using. And this FIIP.com person is coming and he's saying that I have been using from last 3 years, wherein you have just got it granted now today. So I am not supposed to supposed to give up my rights, because I have generated my rights through my use. So as in our slides also we have said that trademark rights are also generated through use and through registration. Because registration is not mandatory. Registration is done, but if somebody comes with the prior use, then that person can definitely take action against you, saying that I am using this trademark since 20 years, 25 years, whatever, and you have come up and got it granted now. So based on use, I am the prior owner of this trademark. So it's possible. So there are multiple situations in the market which can be solved in different manners. Prior use is very important. Yes.
मैडम इसमें ट्रेडमार्क यूजर को वेटेज ज्यादा रहेगा या डोमेन जिसने लिया है उसको वेटेज ज्यादा रहेगा, या जो बहुत सालों से चला रहा है उसको वेटेज रहेगा?
Who is using it since long and is able to establish his use, prolonged use, that person can be a domain registrant, or that person can be trademark registrant. So whoever has been using it, that person can claim the exclusive right. Because as we have explained that trademark right can be established through trademark infringement also, or through common law also by passing off. There is one other option, passing off. If I have not, like FIIP.com, the domain owner has not registered his trademark and he has been using in the market since long, then he can sue Navnath sir based on the prior user and the reputation, goodwill earned by him through the many years of his practice by passing off action. He need not to register his trademark through, and he need not to claim for trademark registration, trademark infringement, because he has not registered his trademark itself. So he can definitely claim his rights through passing off action.
So the role of advocate, trademark consultation plays a very important role.
Yes.
Right? Because that is where it is really important. Perfect?
Yes, it's all litigation. Yes, litigation matter, and how you can prove the matter in the court of law. That is a tricky process.
That is sometimes a tricky things now, because you have to prove that you are using this brand prior to the opposite parties. So that is where I think the trademark consultation plays a very important role, because that is really
Yes, yes, yes. As we have seen the case of Nestle and ITC just now. In that case also same thing happened. Registration was not done, but it was opposite to this situation because ITC had not registered it, and they have to claim it through passing of action. Okay, so in that case they couldn't get through because they were not branding it correctly, the magic masala. But in this case, if FIIP.com domain owner is able to establish his proper branding and his prior use, he could produce his all prior user details in the court of law, then he will get it granted. The more weightage will be gone to him.
Okay, great.
थैंक यू मैम. आई थिंक सभी का सवाल अभी खत्म हुए रहेंगे. वेरी वेरी इंफॉर्मेटिव सेशन. लॉट ऑफ डाउट्स आई मीन क्लियर्ड. इनफैक्ट मतलब बहुत सारे लोगों को काफी चीजें पता नहीं है. इनफैक्ट सिर्फ ट्रेडमार्क होता है, रजिस्ट्रेशन करना होता है, इतना ही पता है. बट देयर इज समथिंग कॉल्ड डोमेन, देयर इज समथिंग कॉल्ड ओके ट्रेडमार्क, पेटेंट, सब अलग अलग चीजें हैं. विद इन आईपीआर एक्ट देयर आर सो मेनी things to be protected. IPR is a platform to protect all these requirements. ब्रांडिंग है या आपका प्रोडक्ट है, लाइक मतलब पेटेंट है या ट्रेडमार्क हो या कॉपीराइट हो. So all these things have to be protected. Is very very important. Very informative session, very in detail. बहुत ही systematically आपने समझाया है. And I hope all of you got benefited. I think thank you once again, ma'am. Mohini ma'am, thank you so much. It was a wonderful session. On behalf of FIIP, I thank you once again.
So
okay, I take this opportunity to thank FIIP for providing me this wonderful opportunity to play my bit in FIIP. Thank you very much.
Really, it was a well.
Thank you for hearing me patiently. Thanks a lot.
थैंक यू. यस ऑडियंस, एक्चुअली नेक्स्ट वीक के लिए हमारा नेक्स्ट सेशन है अंडर नवऊर्जा प्लेटफॉर्म. दैट इज सेकंड टॉपिक अंडर नवऊर्जा प्लेटफॉर्म, दैट इज माइंड मैनेजमेंट
Thank you very much.
योगा
It was
फिलॉसफी.
very informative. Yeah, I am logging off.
So stay tuned for next week. Block your time and date. तो बहुत ही इंफॉर्मेटिव सेशन रहेगा. देखिए, बिजनेस तो हम करते रहते हैं, राइट, बट बिजनेस करने के लिए या ये करने के लिए हमारा माइंड को कंट्रोल करना, माइंड को मैनेज करना बहुत ही इम्पोर्टेंट है. तो नवा ऊर्जा एक प्लेटफॉर्म है जहाँ पे हम सोशल एंड लाइफ के बारे में, एनवायरनमेंट के बारे में, हेल्थ के बारे में अलग अलग टॉपिक हम सेशंस ऑर्गेनाइज करते हैं. तो नेक्स्ट वीक के लिए मिस्टर शिवराज माने, सोशल एक्टिविस्ट, वाज ऑफ कोर्स रिटायर्ड पुलिस ऑफिसर है वो. तो अपना काफी मतलब टाइम सोसाइटी के लिए डेडिकेट करते हैं. उन्होंने अपना ड्यूटी के साथ साथ योगा और माइंड मैनेजमेंट काफी स्टडी किए हैं. इवन ही हैज डन फिलोसफी इनटू दीज थिंग्स. तो मेरा ये रिक्वेस्ट रहेगा, आप नेक्स्ट वीक के लिए 10 तारीख को 7 बजे सेम यही टाइम है. तो फॉर दिस टॉपिक प्लीज रजिस्टर करिए. यू विल गेट द लिंक सून. ओके, थैंक यू सो मच एवरीवन. नवनाथ सर, वुड यू वांट टू से समथिंग?
यस सर. सो सारे पार्टिसिपेंट को रिक्वेस्ट करूंगा कि जैसे कि अभी सीवीके सर ने बताया कि नेक्स्ट वीक हम लोग नवऊर्जा प्रोग्राम में लेके आ रहे हैं माइंड मैनेजमेंट थ्रू द योगा फिलोसॉफी. योगा फिलोसफी से हम लोग हमारा माइंड का कैसे मैनेजमेंट कर सकते हैं, ये इसके ऊपर मिस्टर शिवराज माने जी हम लोगों को गाइड करने वाले हैं. सो आई रिक्वेस्ट टू ईच एंड एवरीवन कि आपका जो नेक्स्ट सैटरडे का इवनिंग का 7 बजे से 9 बजे तक का जो टाइम है वो आप आपके पास रिजर्व रखिए ताकि आप इस सेशन का बेनिफिट ले सके. सो जाते जाते मैं एक थॉट यहाँ पे आप लोगों को देना चाहता हूँ. आज इंडस्ट्री इनसाइट्स का प्रोग्राम था, तो इंडस्ट्री के बारे में, बिजनेस के बारे में एक छोटा सा थॉट प्रोसेस में बोलना चाहता हूँ कि कोई भी सफलता जब हम लोगों को मिलती है, तो आमतौर पर उन्हीं लोगों को मिलती है जो इसकी तलाश में बहुत व्यस्त होते हैं. सफलता पाने के लिए उसमें व्यस्त होना भी जरूरी है। उसकी जो तलाश करता है उसी को सफलता मिलती है। तो इसी कोट के साथ मैं आज का सेशन यहाँ पे स्टॉप करना चाहूंगा। यहीं पे आपका सब लोगों का थैंक्स बोल के रजा लेना चाहूंगा। जितने भी पार्टिसिपेंट थे सब लोगों को मैं आज दिल से धन्यवाद देना चाहता हूँ कि आप लोगों ने ये प्रोग्राम को पार्टिसिपेट किया, इसका बेनिफिट लिया। और इसके साथ साथ में जो डॉक्टर मोहिनी सूर्यवंशी जी जो है, उन्होंने उनका कीमती समय इस प्लेटफॉर्म के ऊपर दिया और उन्होंने काफी अच्छी तरह से हम सब लोगों को एक्सप्लेन किया कि ब्रांड वैल्यू क्या होती है। ब्रांड वैल्यू में जब लिटिगेशंस आते हैं तो वहां पे किस तरह से प्रॉब्लम्स आते हैं, कोई भी ब्रांड हम रजिस्टर करते हैं तो उसका इफेक्ट क्या होता है। तो ये सब चीजों के ऊपर मोहिनी मैम ने हम लोगों को काफी अच्छी इंफॉर्मेशन दिया है और इट्स अ वेरी नाइस सेशन। सो थैंक यू मोहिनी मैम, और इसी के साथ में मैं यहाँ पे रुकना चाहूंगा। सो थैंक यू वेरी मच एवरीवन।